Hello, welcome back to the channel and thanks for watching. Today's video will follow a quite different format compared to what I've posted in the past. I believe that watches have always had an interesting relationship with intellectual property. The reason is that there's a lot going on behind these small but complex objects. Surely more than what we, watch enthusiasts, normally take into account. So, how much intellectual property, or IP, can there be in a watch? The first type of IP that we will talk about is the patent. Patents are exclusive IP rights that can be granted for inventions. Generally, this will refer to new ways of doing something, new ways of solving a technical problem. In order to obtain a patent, the inventor or patent owner must disclose the technical information to the public. This is an integral part of the patent application. So the first requirement that must be met to achieve patentability is novelty, which often revolves around what is known as an inventive step. This method is used to ensure that the novel feature of an invention is not superficial and truly leads to a useful technical solution. Other criteria refer to non-obviousness and usefulness. Non-obvious basically means that the invention should not be just an obvious deduction for the skilled person, or in other words, not just a variation of the already existing technology, processes or methods. The usefulness part refers to commercial viability, or in other words, there should be a market that can benefit from that invention. Now that we've discussed what patents are, let's see how they relate to watches. There are of course many watch brands that have developed amazing inventions. However, during this video we will take a closer look at Omega, Longines, Panerai and Rolex. The first thing that comes to mind when talking about watches and patents is very likely the movement, and there are many patents protecting the technical aspects behind actual watch movements. However, I thought it's going to be more interesting to take a granular approach here, as patents could protect just one component of the movement, and not necessarily the whole thing. For example, George Daniels, the British master watchmaker, had a patent just for his coaxial escapement, the very same bought by Omega from Daniels in 1993. This gives us a very good and easy to understand example of why Daniel's invention was granted a patent. The normal lever escapement involves sliding movements, which cause friction and over time wear and tear on the components. What was novel in Daniel's coaxial escapement was the fact that it no longer involved sliding movements, but relied instead on a sort of push movement. The technical problem this solved was exactly that wear and tear associated with the lever escapement. Less wear and tear meant an increased service life of the components. Another, now also more affordable watch brand that has an interesting relationship with intellectual property is Longines. I chose this because obviously affordability is the whole theme of this channel, and I truly believe that some Longines watches really do come at reasonable prices. Just to give you some examples, some of the very first Longines patents were filed in the early 1900s. US patent 792414 was published on the 13th of June 1905 and described a stem winding and setting mechanism for watches, or US patent 793153, published on the 27th of June also in 1905, described the device for fixing watch movements in their cases. That's pretty much what I wanted to share with you regarding patents, as I'm trying to not be too boring. I think it's time that we talk about trademarks now. Firstly, what is a trademark and what can be registered as a trademark? A trademark is a badge of origin. It can be any sign or symbol that is capable of helping customers differentiate the goods and services provided by one organization from those offered by another. There are many types of trademarks, but some key ones to remember can include words, logos and slogans, and very interestingly, even sounds. We will talk about sounds more a bit later. We can go back to Longines for a moment. Ernest Francion, who founded Longines together with Auguste Agassiz, was a true pioneer when it came to protecting his products against counterfeits. Longines are actually explaining on their website how Francion ensured that all timepieces leaving the factory were engraved with a serial number, the trade name Longines, and its winged hourglass symbol. In 1880, a Swiss law for the protection of trademarks was introduced, and right away Francion registered his trademark. Almost a decade later, in 1889, he also took the Longines name and the winged hourglass symbol to the newly formed at the time Federal Office of Intellectual Property. Currently, trademark protection can cover international markets through WIPO, the World Intellectual Property Organization, but the forerunner of WIPO, which was known as the United International Bureau, was where Francion registered his trademark as soon as this was established. According to an article posted by WIPO magazine in March 2005, the hourglass logo of the Longines watchmaking company is the oldest valid trademark in the International Registry at WIPO. The article also states that the Longines trademark was the 14th application filed in the registry, but the preceding 13 marks have lapsed in the intervening years. This basically means that they were abandoned by their owner. Moving on to another watch brand, unfortunately not a very affordable one, but still good for us to discuss in case you're interested in diving deeper into the trademark world. We all know and love the iconic Panerai design, but no, it's not what you think. We are not yet going to start discussing designs. We are still at trademarks. And this is where things may get a bit confusing. I will, however, do my best to shed some light on the matter. Shapes can also be registered as trademarks, as they can, like logos and words, help distinguish one company's goods and services from another. As mentioned before, another less common example can be the sound mark, but you should know that even colors can be registered as trademarks. Trademarks refer usually to items which are mainly decorative and non-functional. To protect the function aspect, then we must go back to patents. Panerai, of course, can and very likely is protecting its watch case appearance with a design IP right as well, but we will talk about designs later through the lens of another iconic watch brand. From Panerai, I have what I believe it's a quite interesting example of what is still a trademark registered to protect the shape of the Panerai crescent, basically the crown protection. As we all know, this has a functional purpose as well, which could surely be protected by a patent. However, the trademark we're now referring to only protects the shape of the crescent. This is registered in the US under serial number 866-11369, in case you want to take a look, and was published on the 22nd of March 2016. According to the USPTO TSDR service, the mark consists of a three-dimensional configuration of the bridge of a watch. The dotted outline of the watch case is not part of the mark, but is intended to indicate the position of the mark. The next phrase in the mark's description continues in a similar fashion and interestingly explains what from the image is not protected to basically tell us that the Panerai crescent is. Earlier I mentioned the concept of registering a sound as a trademark. This is also known as a sound mark. To give you an example of this, a trademark can be registered whenever a sound is used to help customers identify the commercial origin of products and services. A very well-known example of a sound mark that will help all of you watching this video resonate with the concept is the MGM, Metro-Goldwyn-Mayer Lion Roar. Why exactly am I mentioning this? Because during my research for this video, I failed to find a sound mark registered by a watch brand. However, I believe this should be very much possible, and what can be better at illustrating this than Patek Philippe's collection of minute repeaters. On their website, Patek Philippe state, the final validation for the chimes of every Patek Philippe minute repeater is from the president of the company himself, Thierry Stern. Like his father and grandfather before him, it is his duty to confirm that each chime achieves the standard of Patek Philippe sound. There are three core criteria that he takes into consideration: the harmony of the chime, the balance of the chime across minutes and hours, and finally, the length and depth of the chime. Now there is the possibility that Patek Philippe already has a sound mark for the chime of its minute repeaters, and I just couldn't find it. But there are also two other reasons I can think of that could explain why the chime wasn't registered. One, maybe not all watches are able to reproduce the exact same sound, and two, maybe nobody cares to protect the chime, as building minute repeaters it's an extremely expensive endeavor anyway. I am curious to hear your opinion on this matter, so feel free to let me know in the comments below what you think. The third and last IP right type that we will be discussing today is the design, and this is also very important in the world of watchmaking. So what can be protected by designs? In a nutshell, the visual appearance or the external look of an item. To illustrate the relationship between designs and watches, we will refer to a very recent example from Rolex. On the 23rd of March 2023, Rolex filed a Swiss design application with number 2023-00184/1. This can be found on the WIPO website. The French title of the design is Boîte de montre, which literally translates to watchbox, but actually means watch case. Why I chose this particular example? Simply because it protects the design of the new Rolex Daytona, and personally I find the Daytona in general to be the most attractive Rolex watch. You will notice in the images of this design the recent addition of the Cerachrome edge around the bezel. I've seen that there is a bit of a debate in the watch world around this new model, but I for one really like both the Cerachrome edge and the transparent caseback. To conclude, I hope that I managed to answer the question initially raised by this video. How much intellectual property can there be in a wristwatch? Well, now we know that a timepiece can be protected by all the main types of IP rights, and hopefully this video helped you get an understanding at a more granular level of how different IP rights may be applicable to specific components of the watch. I hope you liked the video, and if you did, as always, please feel free to subscribe to the channel. Thank you and see you next time.